You know what? I messed up. Let's do that again. Redo, mulligan. All right. And doing this again. All right, and we are live now. Second try's a charm, maybe.
Perfect. Does anybody know if we're live on LinkedIn for sure?
We'll figure it out. I know we are live on YouTube. That's good enough, but I'll check on LinkedIn. Why don't you?
All right, you do that, and I'll do the intro here. So welcome to Your Bytes, Your Rights. We are a live weekly discussion and podcast about data ownership, digital rights, and your privacy. In episode 30, we talk about the unprivacy of employee data. Thought I was getting an echo there. What data is your boss collecting on you? Can your employer monitor your private email? Can they fire you for social media posts? Do you have a right to see your employee file? These are questions that we might have at any point in time, but employee privacy is changing. There's lots of remote work now after COVID, and CCPA is giving DSAR rights to employees as of 2023. Are employers striking the right balance between employee privacy and crucial data collection? We explore these questions and many more. I'm Jeff Jokish, founder of Privacy Plan and a vocal data privacy researcher. I live at the intersection of privacy and data about privacy. I'm here with my co-host, Christian Kmeyer, managing partner at Sustany Capital. Chris runs a VC fund that focuses on blockchain solutions. He's into privacy, identity, the future of money, and recreating reality consensus again. Say hello, Chris.
Hey, Jeff. Apparently, we are not streaming on LinkedIn, but I'll try to fix it. So in the meantime, the YouTube stream is working. So I'm also your trusty amateur broadcaster here, and we're trying to fix that as well.
All right. Well, let's introduce our distinguished panel of one. That is Odia Kagan. She's a partner and chair of GDPR compliance and international privacy at Fox Rothschild. Tell us about yourself and about Fox, Odia.
So I'm a data privacy partner, and I focus on helping companies that have sophisticated data needs in a variety of industries to figure out what legal framework applies to them. Are they in GDPR? Are they in CPRA? Are they in BIPA? Are they in all of the above? And what does that mean from a practical, pragmatic perspective of what they need to do? Can they collect this information? If they can collect it, what do they need to do? Do they need to give consent, and opt in and opt out, a notice, a pop-up? How long can they keep it? How can they share it? That's basically what I do from the day to day. And I have a team of attorneys that I work with on this. And obviously at Fox, we're a full service firm, and we do all sorts of other areas of privacy that are less in my wheelhouse. And then obviously, full service lawyering throughout in 29 locations in the US.
Well, I love your LinkedIn posts. You're one of the go-to lawyers for compliance when I've got a question, and so we really appreciate you being here. You've been here before a couple of times, and we always enjoy having you. So thanks for coming again.
Thank you for having me.
Absolutely. I wanted to sort of start with an overview about this particular area of employee data privacy. I think many listeners that aren't steeped in privacy law may not really understand that this part is a little bit different. Peter Swire's book, I'm actually blanking on the title now, but it's the manual that we use for CIPP US certification, has a really great sort of overview. And I'm actually going to read from it a couple of paragraphs. There is no overarching or organized law for employment privacy in the United States. Federal laws apply in specific areas such as prohibiting discrimination, regulating certain workplace practices, including employment screening, the use of polygraphs and credit reports. State contract and tort law, in some instances, provide protections for employees, but usually the employee must show fairly egregious practices to succeed. State legislators have enacted numerous employment privacy laws, providing protections to employees in a bewildering range of specific situations, which often vary state by state. Taken together, there's considerable local variation and complexity on employment privacy issues. Along with laws protecting privacy, many labor laws in the US mandate employee data collection and management practices, for instance, to conduct background checks and ensure documents safe workplace environments. Companies have an incentive to gather information about employees and monitor the workplace to reduce the risk of being sued for negligent hiring and supervision of employees. The regulation of employment privacy in the US stands in contrast to nations with comprehensive data protection laws. And then finally, one last little bit, the US law looks at the relationship between the employer and the employee as fundamentally a matter of contract law. A general rule in the US is that employment at will, which means that the employer has a broad discretion for an employee at discretion. In turn, the employee, no, I screwed that up a little bit. The employee in turn has been understood to grant the employer broad latitude in other aspects of the employment relationship, such as issues about the employer's knowledge about an employee. So I guess my question to you, Odie, is can you add your sort of understanding to this? How should employers and employees think about this issue maybe different from sort of standard privacy laws?
Generally speaking, or right now after what's going on in January?
Well, that's a good question, right? Because things are changing, right?
Also, it's the end of September. I don't know if you guys know this, because for me, it's February still. I'm just saying, but it's September for everybody. The year just went away. So January is coming up. I think the one big difference that is happening in January is, and that's going to be my paraphrase takeaway here, is in California, employees are people too. And that's really sort of summarizes what people need to think about. So I think, first of all, there's a very big shift change in California in January, because even though first of all, there are labor laws that in the US that grant employees certain limited rights in receiving copies of their HR files. Okay, this is a thing. However, there is a delta between my HR file that I'm allowed to see and what I get now under CPRA, number one. Number two, there are, the interesting thing is, I think everything that you read is correct. Then the implementation depends, right? Because there are a variety, there is no overarching comprehensive law. That's correct. There are, though, laws that impact how you do things. So, for example, there are a bunch of laws with respect to employee surveillance and the disclosures associated with it. So, for example, like in Delaware, right, you have to have this annoying pop-up thing on your computer every time you restart the computer saying, blah, blah, we monitor. And then there are other things that deal with specific aspects. For example, discrimination, obviously. For example, AI, machine learning in hiring and, recruitment also. So there are now certain aspects that are being BIPA, obviously, right? Biometrics. So there are different aspects that attribute everything. I think the shift change in California is that now it's not just, specific little rights and things. It's basically, hey, the employee's position with respect to their data is the same as the individual's position with respect to the data. You get a universe of rights. And I think that's a big difference. And we can obviously get into what that means. But I think that's a big difference, is that employees are now on par with consumers in California.
Yeah, let's talk about that in a moment. Right before this sort of came on, I did another post to sort of talk about sort of the types of data that employers actually collect. And I think maybe it might be good to sort of go into that a little bit for our audience before we actually talk about those DSAR rights. Because if you don't understand what data might actually be available, it may not make as much sense. You may not understand what the ability to get that data would mean. So let's talk about what that data might be. I was just sort of off the top of my head trying to think about all the different data that an employer could potentially collect about an employee. So I was thinking about all the information that might be in your HR system, which might include things like identity documents, right? Maybe even passports and Social Security cards and birth certificates. You might have payroll information, benefit information, employee safety information, hiring and promotion stuff, performance and discipline, demographic information for EEOC compliance, medical data, attendance data and punctuality, system usage, mouse clicks, computer tracking, system privileges, background checks from the hiring stuff, drug tests, biometric data for you talk about BIPA, right? Images, fingerprints, names and stuff all through the email systems. Some other people chimed in some stuff that they didn't add to this list. It's a whole lot of information when you start thinking about that a company probably has collected on you throughout all of their information systems. It's even way more than they probably have about a consumer.
I think it is, right? And a couple of things that I want to add to that, because now with the there's some non-traditional things that are being collected. Information, for example, or maybe not just collected, but the use, right? So for example, like facial expressions and analyzing emotions. There was a case in Hungary with respect to a bank that was using some AI to analyze the emotions of the tellers. So like, facial analysis, like, language analysis in emails with respect to mood, right? We know that Facebook did it. We know that the technology is there. Location, like precise geolocation inside the building, especially in the context of the return to work, right? So there's a lot of first of all, as you said, HR is one of the areas where it is almost clear, almost 100% chance, probably 100% chance that the employer is collecting sensitive information about the employee, right? When you were looking at CPRA compliance, and one of the big things that's changed is this concept of sensitive information, you're tracking and exceeding the GDPR special category data. Right. When you look at it, this usual suspects is obviously HR, right? Because medical, because FMLA, because diversity, because of all that, right? So first of all, there's more data, maybe. There is more sensitive data. So then usually this is, when you look at the analysis of it, sometimes or traditionally, this was mostly counteracted with the fact that it was used for the expected purpose, right? Like, okay, my medical data, in order to get me the workers' comp or sick leave or FMLA or whatever, right? However, when employment practices are changing, now you have one new, maybe unexpected, unexpected and secondary uses of the data, which are now that need to be dealt with, right? Because of the sensitive information. Do you need a DPIA, right? A risk analysis? Yes, you probably do, right? Do you need to do a data minimization analysis? Well, before it was a no-brainer. I'm using your bank account information in order to pay you. Well, okay, that's just necessary for the purpose. But if you're using suddenly my facial expressions in order to gauge my work satisfaction or likelihood to quit, that is a different issue. And so that's how things are starting to get more complicated in the HR area.
Yeah, those secondary uses and inferences might be problematic, right? If you haven't done a DPIA.
Right.
And so now, go ahead.
So secondary uses is a couple of things. There's actually, the disclosure component. So maybe like step back and say, what are the rights that you get, right? Just, at least to start with. So before the DSARs, the one thing that employees always have had, since CCPA, right? This is not a CPRA thing, but it's, CCPA, right? Is disclosure, right? Employees have the right, as of CCPA, as of now, right, to understand what is going on with their data. That's kind of already clear. What's become clearer, and this is pursuant to, and we had, I think, a session specifically on disclosure with you guys, but pursuant to the European case law on this, as well as the new CPRA regs, the standard for disclosure is much higher. And so you need to be specific with respect to your disclosures. So you can't just say, we collect information for employment purposes. Well, what does that mean, right? Like, what are you actually using it? And if you're using it for secondary purposes, you have to, number one, disclose it. It's actually number two, disclose it. And number one is the data minimization expectation analysis of, am I even allowed to do this? Is the employee expecting that I am going to use their information in this manner? And you have to be realistic, right, about this. Like, you have to be, this really has to be something that they're expected, because the standard for expectation in the CPRA regs is pretty strict.
That makes sense. So let's talk about those DSAR rights now. What's going to happen? It seems to me that there's going to be a huge problem as employers are now, as of 2013, going to have to respond to DSAR requests from employees. I mean, I can see a lot of disgruntled employees or just curious employees wanting to see their employee file. And sending in a lot of requests, and I don't imagine that the DSAR processes that have been put in place by OneTrust and Wirewheel and all of these other platforms are actually tied into all of the employee data, at least not fully.
So I don't know. One, I don't want to opine on any specific product or anything, but the principle is this. First of all, yes. Okay, like I actually did a webinar on this with a few of my privacy friends in Europe and in Canada that have been dealing with employee DSARs, and it is very it's difficult. Let's go with that. Let's not say nightmare, but it's difficult. The reason is that when this happens, it happens with, as you said, disgruntled employees, and disgruntled employees. There is actually case law and guidance, not case law, but like supervisory authority guidance. And I think also decisions that have in Europe that said that the intent of the employee or even person, whatever, the intent for filing the DSAR doesn't matter as long as the DSAR is valid. And so even if you know that the employee is only filing this because they're disgruntled and they want to make life difficult for you, that doesn't matter. You still need to fulfill their rights. And that is very clear in GDPR. And that part is actually the latter, that we don't have decisions on the intent, but we do have very clear language in the law that you can't discriminate against anybody for exercising their rights. So you can't say, ooh, we don't think we're going to not do this because whatever, we're upset, right? So one, yes, there's potential for a lot of these. Let's go with that. Then the complexity, I think, even before like the tech, right? Because in my, so I'm a lawyer, obviously I would say this, but I really believe, right, that the substance goes first and then the text supports the substance, right? So the substantive issue is here because in the US, this has never been a thing. And also it hasn't been a thing for CCPA. So when everybody was buttoning up and assessing and looking at their third-party relationships with respect to service provider designation or analysis of, is this a sale? Is there an opt-out? Like when people were doing that, they naturally skipped all of the HR vendors because wasn't relevant, right? Like you didn't need to do that because it was just employee data. But now, you know, as HR processes have become more complex, this is no longer, you know, somebody, Joe from HR, pulling your file, right? This is payroll outsourced, benefits outsourced, medical outsourced, 401k outsourced, sometimes disciplinary or whatever training and whatever executive training or something outsourced, right? Attendance sometimes outsourced, right? So there's all these vendors that hold the information on your behalf. And if you file a DSAR, that DSAR needs to include all of that information, number one. And number two, it needs to include that information in a way that a human being actually understands. And that part is complicated because now you have to track down all these things and figure out what they are and how they're going to work.
So what's the recourse then if an employee files one of those requests and he has strong reason to believe they just shirked him, they just gave him some minimal information that they were comfortable with, but mostly withheld information that they had?
So this is interesting. There have been a number of cases like this in Europe, not specifically in the employee context, but there have been complaints to the DPA, right? So in this case, it's going to be complaints to the CPPA that this is a violation of rights, right? So we know that CCPA, CPRA do not have a private right of action other than with respect to data breach, right? That applies to employees too. So they can't file a lawsuit for a CCPA breach, but they can file a complaint with the CPPA. CPPA, as of January, is no longer required to give you a mandatory 30-day cure. And therefore, you know, if they decide to investigate you, then they can investigate you. And there's been decisions in Europe about this, specifically either not answering or providing an answer which was not complete.
So who in the United States outside of California has actually enforced employee rights, if anybody, or is this largely unsettled at this point?
So there is case law with respect to certain aspects of employee rights. And by the way, my sense of it is that we're going to see more of it under traditional causes of action. And I will explain. So first of all, there is case law, California, and I believe other states as well, with respect to things like employee monitoring or surveillance in that was not known, right? Especially things like accessing, you know, first of all, the obvious things, which is like accessing personal correspondence, right? There's case law about the employer was accessing an employee's Gmail just because it was like on the screen, right? Or, you know, your personal text messaging. That's why there are the bring your own device and the mobile device management and all of the notices and consents that you have to go through it or that's sort of like, you know, as we say, kind of learned in blood, right? And there is case law, which is, I think, going to get renewed life, especially in California, but generally, because with respect to excessive invasion of excessive invasion of the employee's, I don't know, correspondence or whatever. Now there is the concept in this situation is the expectation of privacy, right? Like, do you or do you not have an expectation of privacy? And this is something, I think this is a concept that is in flux because of the new and unexpected uses of information. And so whereas you could say, oh, like it's obvious that, my employer looks at, which websites I'm browsing. One, by the way, it's not that obvious. That is why you have these acceptable use policies, right? But some things are sort of, yeah, I understand that that's happening, but there's some uses that are, innovative uses that are unexpected, especially, by the way, when you're using one thing for another purpose, like, like in the Twitter FTC case, where, hey, we're collecting your phone number for security purposes, but actually, oops, we're going to use it for other purposes. So I think that part is an FTC problem. And FTC is, fair game for companies for uses of the information. So I think that is one aspect to watch, is kind of, misleading secondary uses. And the other is that we have been seeing a lot of new privacy cases using old causes of action. For example, wiretapping. There have been meta pixel wiretapping cases, session replay wiretapping cases. And so in that situation, use employee monitoring. Why would it not fall under wiretapping, right? And so that's to the first point that we were talking before, is that yes, the US does not have a comprehensive privacy law, but it has these Rorschach painting blobs that sometimes start to get close to each other and do cover, big pieces of employee rights anyway.
That's interesting about the wiretapping play. We're seeing a lot of lawsuits that sort of throw in the wiretapping claim, Odia. Are any of those sticking in employee privacy or in other privacy lawsuits?
So far, I've seen them pop up. And I think they're all pending, but I've seen a lot of them pop up and really different. One, wiretapping; two, UDAP, right? Misleading, deceptive. And so I think that's going to be really, there was even a wiretapping biometrics lawsuit a couple of days ago. So this is in Illinois, BIPA. It's voice print as wiretapping. So I think this is going to be really interesting to stay tuned and watch how these things develop, because it's sort of like, there's a arguably legislative, vacuum, and then old causes of action are getting new life to kind of fill it up.
Yeah, I don't know that it applies so much to workplace privacy, but I saw another interesting claim recently. I think it was on a data broker case. It was the Irish Civil Liberties case against Oracle, where they claimed unjust enrichment, which I thought was an interesting claim. So that probably doesn't fly with workplace privacy.
I don't think it does, but I would say something that I did want to mention, which is with respect to the CCPA stuff, which is even under CCPA, but definitely going forward, right? Like the carve out was as with respect to the employment. So when you're starting to use employee information for things that are not strictly employment related, like, hey, I'm going to share employee data because I'm going to get a discount on something else, right? Like that is definitely something that's regulated under the law anyway, right? And arguably, by the way, in my opinion, would be regulated under the other laws, because the carve out in the other laws is about employee data as employee, right? And this is not employee data as employee. This is employee data as fungible token to do something with it.
Yeah,
so I don't know.
Very easy to, well, so specifically if it comes to then some dispute between an employer and an employee, you can easily compound that problem, right? So if the employer, for example, was monitoring someone's personal Gmail address and then the employee, because he notices other, let's call it nefarious behavior, but that employer starts communicating with his or her attorney using that email account, but it's being monitored by that particular employer. So now you're in violation of attorney-client privilege, right, as the employer.
I think that area of interfering with an employee's personal communications in their personal email account, I think that probably won't fly under existing laws anyway, because even if you look at your, the standard to measure against is reasonable expectation of privacy. And the argument in the US, which doesn't work in Europe, but in the US and other places, you're saying, okay, well, as with respect to, the workplace, my computer, the employer, my computer, my resources, my electricity, my network, my all of that. When you're at work, you don't have you shouldn't be doing your stuff. And if you're doing it, it should be minimal, and that this is my computer. But as soon as you start going into, as soon as you're going into like personal stuff, that's a problem.
I've got a question, Odia, and I have really no idea what the answer is here. Maybe I should, being somebody what thinks he understands data privacy. If an employee does a DSAR request, an access request or delete request to an employer, what information is actually covered under this? We talked about all those different types of data that an employer might collect. Are all of those things covered under an access request? Certainly, they can't all be covered under a DSAR request, a delete request.
So let's start with a delete request, because I don't know if it's easier, but it's more simple to explain. So the delete request, so one thing that is distinguishing the employee data from, like, let's say consumer data, right, is that so first of all, as we know, right, the right to delete under CCPA, CPRA, same as under GDPR, has exceptions. Right? It is not an absolute right. There are situations where you have a reason not to delete. That reason is more likely to apply with respect to employee data, because usually the employee data, you actually need it because it's an ongoing thing, right? You need it for evaluations, you need it for disciplinary, you need it for payroll, whatever, right? By the way, caveat to that is retention requirements also kicking in under CPRA. And also, as we've seen in Cafe Press by the FTC, you can no longer retain information for longer than necessary for the purpose which it is required. So some traditional HR records are subject to legal retention requirements, right? There's HIPAA requirements, there's tax, things like that. If not, you need to come up with a time that you can, stand for, that you can have a good story for, right? And then you also need to have policies and procedures to make sure that you are abiding by your own policy, because what we've already seen in Europe is case law that first of all, we've seen in Europe case law that attacked the retention limit too, especially in France, very strict with respect to like cookies and things like that. But we've seen more cases where the DPA, the supervisory authority, was like, you know what? I'm not taking any issue with, the term that you said. There was a case where a company said, our term is 2 years. After 2 years, we delete. The supervisory authority was like, 2 years sounds good. Why did you retain it for 5? So that is important, is one, figure out what law applies and if there's legal retention requirements, of course. But if not, then find a good reason and then keep to that good reason. So that's number one, is the caveat to what I said was you can't retain the employee information. You can't. You shouldn't retain employee information for longer than necessary. 1, illegal under CPRA. 2, generally going to be, because of its HR stuff, breach reportable. And why do that to yourself? But generally speaking, And the other caveat is sort of weird uses, right? Like those things with the mood and the whatever, like those are maybe not necessary. And in that situation, you may need to delete those. But generally speaking, employee data is more likely to be subject to a deletion exception. So you need to look and figure out the exceptions. And the other takeaway that I would say in this regard is you need to make sure that your data is structured in such a way that allows granular deletion. We already have, I think this is even in one of the original initial statement of reasons for CCPA, and maybe I think in the enforcement actions, but we already have a statement in California that says, if you need to delete, if you have an exception to deletion, the exception, and I think maybe it's even in the new regs too, if you have an exception to deletion, the exception only applies with respect to what it applies. If you have, let's say, an Excel spreadsheet, for lack of a better example, and you have a legal exception for column A and column B, you still need to delete C through L, right? Like you can't just keep it. And I've had situations where a client said, well, I can't, this is how my system's structured. And in that, the answer to that is, and we've seen case law on this in Europe, is like supervisory authority. When there was a case, I think in Poland, where they were like, no, our system is not set up for this. This is going to be 8 million euro to fix. And they're like, too bad, so sad, fix. So this is something important to figure out is you need to be able to granularly delete because otherwise it's not compliant. So that's the delete piece.
Yeah. I mean, what came up in the hearing this week when Maj was speaking in Washington was that even a large company like Twitter, who's supposed to be fairly sophisticated technically, he was stating that they actually don't even know where they are keeping copy of all that information. And he was, I think, mostly speaking about user data in this particular case, but I wouldn't be surprised if that also holds true for the employee data, since they have people all over the place and probably different systems for that as well, because all of these necessarily have to be interlinked for permission management. And there was another big issue that he said that basically every engineer supposedly has access to all of the customer data, right? So that speaks to another complication, another level that I think by and large is not understood by lawmakers, because they all looked very surprised that for them, by and large, they probably think, oh, it's a delete button and then it's gone. That's actually not in the real world, in the technical space, how that works. Essentially, my conjecture would always be nothing that you ever observe digitally can ever be forgotten, right? It's very, very difficult.
I think so. I hate to be not hate, but I actually love, but to be the lawyer in the room here. But in this situation, I don't think it's necessarily a disconnect between the regulator and life. I think it's more a case of in this situation, in a situation like that, which, the general statement of, oh, it's unknowable what data we have, where it is and where it's going. And that, I actually spoke yesterday at another webinar, and I said, only God's omniscient powers are unknowable, right. And anything else should be knowable. And if it isn't knowable, you got to do something about it. This is not like, it's like those golem kind of, stories of, the beast sort of, now takes over the master and the two neural networks talk to each other and we don't understand, So when that happens, it got shut down. Like that shouldn't be a thing. If the system is so complicated that you cannot figure out where the data is and where it's going and who has permissions, this is not good. It's just not good. Is it going to be difficult to fix? Sure. But it shouldn't have been there. And I don't think this was actually this type of thing. If we don't know where the information is, that's like, I don't know. I think this was problematic under any laws. So I think, but it is true, right, that there are a lot of things that need to be buttoned up. Permissions, by the way, access permissions, that's like, there's FTC case law on excessive access controls as being unfair. There is GDPR case law. There is information security, like, US, there's I think 27 maybe U.S. laws that require reasonable information security protections. I think, excessive access controls probably violate all of those anyway. So this is not a new situation. It's just a lot more, it's a, flashlight that's shining on an existing situation that we didn't think about.
Yeah, you mentioned something earlier, saying something to the extent that permission rights might be a problem, as in an employee not having enough permissions or having too many permissions, or?
So the permissions that I thought you were speaking about is like access. Like, for example, if too many people get access to, so for example, HR file, or let's say, very sensitive data right now is, let's say, reproductive health, or, trans, gender identity stuff. That gender identity stuff, which is really sensitive, right? So in that situation, you, generally speaking, and I am not the information security professional in the room, but the principle is, right, you need to have role-based access that only people that need to know get it, and the levels of permission, right, like view, edit, etc., they need to be tailored to the job. And so only the people that need to do it. And so if too many people, like if everybody can see the information, that's a problem. I mean, there's case law on this in the FTC. I'm pretty sure in the FTC start with security, stay with security documents, I think they talk about this. In Europe, there's definitely access. There was one Guarantee Italy case on Deliveroo, which is kind of like a DoorDash type situation, where they had, they saw all the drivers, but actually, like, everybody's, like, you could be in Italy and you could see like drivers in France, and the Guarantee was like, yeah, this is not good.
Yeah, that was true for Uber as well. They called it God mode, right? So where a significant number of the engineers had access to this God mode and were abusing it to like spy on their access or otherwise conduct nefarious activity. So the question there then is, who has recourse, right? Is the person that's being spied on presumably is the one that's being violated, right? But then ultimately what's cause and effect here is that the employer who is to be held accountable, I would think that they would be, specifically if it leads to certain outcomes, right? So
yeah, I mean, the employer, first of all, I mean, the employer, the buck stops with the employer. Like, if the employer is not responsible, who would be? But I think, and you also need to distinguish between, I guess what the more granular would be to distinguish between, is this a policy, right? Like, do we have a God view policy that everybody gets access, or do we have a policy that not everybody gets access, but somebody went rogue, or there was some accident, or there was some loophole? And in that situation, I mean, there have been cases with respect to employees. I think this was like an SEC case, even not FTC, where there was an employee, I think it was like a advisor, investment advisor or something, who stole the client portfolio as they were leaving their job. And the investigation actually closed because the investment advisor in question was able to show that they have a policy and procedure with respect to where the information is stored and who can do it and whatever, and that you can't take this file with you when you leave. And this was communicated, and they had tech blocks and whatever. And somehow, I mean, when there's a will, there's a way, right? Like, somehow this particular employee was able to sort of circumvent it and do it, but they had procedures and they were monitoring them and whatever. And the case was closed because they proved that they did everything that they could in order to prevent it, right? Like, it's the same as with, data breaches, right? If you need to do whatever you can to mitigate the risk, that doesn't, I mean, if somebody really wants to, they're going to be able to do it.
Yeah, that has been always my gripe. I mean, more often than not, if you call like your bank, your credit card company, then the person on the other end that's answering is somewhere in another country where the wages are lower than in the United States. And all of a sudden, this particular individual has access to all your personal financial data, right? And has access to all your critical questions that you're supposed to answer to disclose certain things. And it's trivial, obviously, for anybody to just do a screen grab, either with their cell phones, even if that system is quote unquote secure enough. And there specifically, the interesting part would be to figure out, are there policies in place and like standards, industry best practices, so to speak, that say, well, this particular, let's call it call center in India, to make a crass example. When you enter the building, your personal cell phone goes into this locker and you get it back when you leave the building. But otherwise, you don't get anything to record data that you have access to and carry it out of the building, right?
Yeah, and there was a case, I think it was, I don't know if it was Pennsylvania, but there was a case with a company where, I can't remember, it was like a debt collection company or something, where they had policies and the people could not, first of all, screen grabs, this is a question on, like, there are ways to lock screenshots and things like that, and print screen and whatever. You cannot, and then you can lock like the mobile device. Otherwise you could like take a photo of the screen that's not a screenshot, whatever. So you can take the mobile away. So in that situation, they had the policy, they had tech lockdowns and stuff. They did have like scratch paper for the customer service representatives to jot down notes as they were speaking. They did have policies that those notes had to be shredded at the end of every day. They did check the waste bins and whatever, but one person, apparently this was like some sort of like actually organized crime, right? The person somehow like was able to get a note and like stuff it in their clothes or whatever, right? And that's something like that. Okay, like I don't know if you would be liable for that, but like there are a lot of companies that, you know, still have a lot of work to do on the first three, right? Which is we have the tech, we have the rules, we have the tech lockdowns, we have the policies and procedures, we have a way to monitor the policies and procedures, right? Like let's start with doing those four.
Yeah, I mean, the other thing, and that's some granular detail again that came up in the hearing on Tuesday, I think it was that like inside Twitter in this particular example, the company didn't even have a way to see who accessed data. So there were no
case law on that. There's FTC case law on it. I'm pretty sure that I've mentioned this before, but like for the listeners or viewers, right? The FTC published like 5 years ago, I think, maybe more, this guide called Start with Security, and then they had a series of blogs called Stick with Security, and I'm like 99% sure that one of those had that particular example of you cannot have logs with respect to access. That's again, right? But any self-respecting information security framework, right? ISO or NIST or whatever, they all have that type of things. There's actually in a European case law, there's actually like granular requirements about what the log looks like and how long do you retain the log and what the log needs to do. But definitely you need to be able to prove who accessed. Otherwise, you know, how do you know if anything was breached?
Yeah. And it goes farther than that. So for a very short period of time after law school, I taught privacy law in Germany specifically, and they're specifically to call centers actually. So I was doing like a test at the end and was asking them, like pretending to be a caller and wanting certain information, right? And asking certain questions like, can you answer that? Are you allowed to give that answer on certain questions, i.e. access logs for like the spouse to an internet service provider or particular sites? And that was generally available at that point in time. That was during the dial-up days, right? So everything was very primitive, but unfortunately, things haven't improved much. If anything, they have gotten worse in terms of data access, specifically in data logs. And the larger point, the things are being is that I think the measures taken post hoc are not drastic enough. I think what some agency must do at some point in time, just say, okay, you have to shut down service until that's fixed. You can reopen your service. And again, this is a little bit skewed because we're talking about employee rights rather than operations of a company, and that's customer facing. But the two are pretty intrinsically connected usually, right? So those are very similar systems, and permission rights are always a part of that subset of what is monitored or should be monitored. So if I was in the position like as the FTC, I would just basically say, okay, we told you to maintain certain things at a certain point in time. You didn't. So we're going to shut you down until you do that. You can reopen your store until you do that.
Yeah.
Anyway, that's just my personal opinion outside of the fact, to reiterate our show's title, that my contention is always that I own all of my digital dust, that have property rights to that, and that I, generally speaking, cannot waive those no more that I can waive the rights to my kidneys in terms and conditions.
We've got a couple. We've got one question I want to get to, guys, and another point I want to try to get into. So Robert Rivera asks about what agencies in America sort of enforce these laws, and I just wanted to sort of get back to him on that. That there's so many different laws in the United States that there are all kinds of different agencies. So it could be the FTC, could be OSHA, could be EEOC, could be Department of Justice. So
and CPPA, don't forget CPPA.
Yeah, exactly, right. CPRA. So yeah, I mean, the enforcement of these kinds of laws are just really going to be all over the map. It's not that there's no enforcement; it's just that it's just so disparate. Lots of attorney generals too, right? So it really depends upon what it is. The other thing that I wanted to maybe get into is I think a lot of people know that I sort of study the privacy agent landscape. A lot of these companies that are now trying to help consumers automate their data subject access rights. And I'm really wondering, when this sort of kicks into gear with employees having data subject access rights, whether one or more of these companies doesn't try to jump into this fray and say, hey, people that are jumping around from job to job, why don't you let us contact your last 10 employers and tell them to delete all your information? Because if they've got as much information as a lot of companies collect, it seems like a pretty good thing to do, given how many data breaches happen on a regular basis. Now, all those breaches aren't necessarily of employee data, but it does happen. If you're cleaning up your data footprint, that might be a pretty good thing to do. So, I mean, the point is, if something like this happens, are companies really going to have to start thinking about taking, automated DSAR processes for employee data seriously? Or is this a one-off thing?
Should they be taken seriously?
Well, I mean, they're obviously going to have to do DSARs for employee data, but
right.
Is it going to be one-off? Is it going to be one a month? Is it going to be one a day? Is it going to be whole bunches of things?
I think it depends on. It depends on I think first and foremost, by the way, it probably depends on your relationship with your employees and former employees. I mean, that's not a legal point, but it's, the more trust you have, the better, the stronger kind of good relationship you have with your current employees, with your former employees, with your alumni. Obviously, the less likely they will be disgruntled and want to get you. Like that. I mean, that's not a legal point. It's kind of a life point,
Sure,
relationships matter and, whatever. Then I think it also depends on the level of complexity, let's say, of your data uses. So if you use like really straightforward stuff like, FMLA and, payroll and whatever, like that type of stuff is, employees already have access to it under existing labor laws. You get access to your, normal employee HR stuff. Some of these things you're required to give copies of anyway, like FMLA paperwork and things like that. So the closer you stay to the necessary for the purpose, which is, by the way, if you look at the GDPR, right, that's one of the legal bases for the HR, right? As long as you stick to, exactly what the minimum, the normal, the expected, okay, your bank account I'm using to pay you, and your this I'm using to employ, that like the more simple your uses of the data are, the less likely you get requests. Because it's like the joke that I have, at the same time that the employee exception is phasing out, the B2B exception is phasing out. And for the B2B exception, right, even before it was phasing out, it really depends on what's your B2B information. Like, nobody's filing an access request for their business card, right? Because like they know the information. So that's kind of the second thing, is that the less sophisticated or the more straightforward, limited uses of information that you have, also the less likely you're going to have. And then the third point, which is sort of not really an answer to frequency, but sort of an answer to what should we do, is one, if you have sophisticated data uses of your employee data, or generally, talk to a privacy counsel and fast, right? Number one. But number two, you need to look at your processes anyway, and just with a prism of, it's like, the tagline for the New York Times or something, like all the news that fit the statement that says, if you don't want to see it in the newspaper tomorrow, kind of thing. So now your HR stuff is fair game. So, I mean, I've heard, situations where, I want to file a complaint against a bad employee. I'm going to email you the details. Don't email the details. Like, it's not a good idea to say, oh, Joe is stupid. Like that, like record, like the manner of records, right, in the files, in the notes. Like, do you really need informal handwritten notes in the formal file? Like, you want to look at your processes and with a new prism of saying, you know what? This is now fair game for something that is akin to discovery. Do I need it there? Am I required to have it there? Is there a better way to do it?
Yeah, I think that's really good advice for companies. It occurs to me, if I'm an employee of a company, do I even know what their data, their employee data practices are? Would I know if they're doing a lot of,
I'm going to answer this in the facetious way. If you do not, then that means your employer is currently in violation of CCPA.
That's a great
because they should have been telling you this. You should have an employee privacy notice. The employee privacy notice needs to be human readable and in sufficient detail for you to understand it. And until now, this and the data breach were the only rights of employees. Now they get a bunch of other stuff, but you should have known this already. And if you didn't, then you should know now. So yes, you should know what they're doing. And if they're doing fancy stuff, they should tell you about the fancy stuff. And arguably, for some of the fancy stuff, you may have a choice with respect to whether or not they're doing it. And maybe they shouldn't be doing it anyway, because they should have done a data minimization test. But the first layer is, yes, you should know. You're entitled to know.
I've got one final question for you, Odia. Is this right going to spread quickly to other states, other places? Obviously, it's already like in Europe, right, and maybe in other privacy laws. But is it going to spread across the country? Do you think other states will adopt this?
So this is interesting. So the other 4 have not, right, with the existing laws.
Right.
However, ADPPA, which, there was a huge, and there wasn't is, hopefully is. I really don't want to talk about ADPPA in the past tense. I want to be hopeful and talk about it in the present tense. But there is a discussion, the preemption discussion, and there was a carve out for employee rights, which means that, at least as with respect to the current thinking in the ADPPA, this employee thing is a states' rights issue, and each state can do its own thing. So far, California was the only one that did it. And that perhaps doesn't mean that other states won't, pick this up later.
Yeah, it's being discussed in New York, Connecticut, and Delaware at the moment, according to an article that we found on The Hustle. So hopefully, eventually, it's going to be a federal thing of sorts. Jeff, we're at the top of the hour.
We are.
Believe it or not, we never managed to turn on the LinkedIn stream, so apologize to anybody who was trying to watch it there, but I think everybody who wanted to watch it found us on YouTube. So we'll give that another try next week.
We did get it recorded, so everybody can catch up with it, which is great. So we want to thank Odia for all of this great insight and Fox Rothschild. And so I guess we'll see everyone next week if you're interested. We do not have a topic yet. So if you have ideas for topics, send them to us. And this has been Your Bytes, Your Rights, episode 30. And we'll be back next week with episode 31. Hope everyone has a great weekend.
See you next week.